Hi all, I'm Isabel Syrad. I'm the Service Manager for Divorce, and alongside me is Kimberly Hancock, Deputy Service Manager for Divorce. So welcome to the webinar. We're here to just talk to you about and share with you the videos of the solicitor divorce journey for the sole application and also the joint application, and also here to answer any questions that you might have. We've been live obviously since last Wednesday with the new divorce law, and we can see from the number of applications that we've had in that the service seems to be working really well. So we're getting completed divorce applications from both citizen and solicitors. So thank you for that. Just to cover really the changes for the new divorce law. The changes cover really, you can apply for a divorce either solely or jointly. The digital service supports that from both the citizen and also the solicitor. And it also covers the 20 weeks. So after the case is being issued jointly, that then is a 20-week reflective period. A respondent has 14 days to respond to the divorce in a sole application. So those are just a brief summary of the changes with the new law. We also have, rather than a defended divorce, a disputed divorce. So you can only dispute on two grounds, either the jurisdiction or the validity of the marriage. We also have, with the new online service, you can now apply for your civil partnership online. So you can also do that as well as divorce. In the old divorce law, you couldn't apply for your civil partnership online, but you can now do that on the new divorce law. Okay, so what I'm going to do now is I'm going to hand over to Kim, who's going to just take us through a couple of the videos, and then we'll answer some questions at the end. So we're going to look at the sole divorce application first, and this is how a solicitor can apply for a divorce application on a sole application.
So today we're going to look at how a solicitor applies for a sole application in the new law. The solicitor will log into their online portal. You'll click on Create Case. You'll select Family Divorce, New Law Case, and apply for divorce or dissolution. Then Start. Next, you'll just choose whether this is a divorce or a dissolution that you're applying for, and whether it's a sole or a joint application. Next, you're asked to input information about the solicitor. So this is the solicitor's name. The reference number is optional. Suggested that you do put a reference number in, as it might be easier to track the case further down the line. And your phone number is also optional. You need to provide the solicitor's address, email address, and that you're willing to be served via email. Next, you need to look up your solicitor's firm. Once you've found the one that you're looking for, you click Select. If you need to make any changes, you can click the Clear button on the hyperlink. Next, you've got to state that the marriage has irretrievably broken down. If you select No, it does state that you have to have had the marriage irretrievably broken down to get a divorce. Next is the information about the applicant. So the applicant's first name, applicant's middle name. It is advised that if they have a middle name that you do put this in to avoid any amendments to the decree, to the conditional order or final order further down the line, which could cause delays in the application. You're asked if the applicant's name's changed or is different to that on the marriage certificate. If you select yes, you get options as to how the name has changed. Who is the applicant divorcing? This is who the respondent is in the application and not who you as a solicitor are acting on behalf of. And you're asked if it is a same-sex couple or an opposite-sex couple when they got married. You need to provide the applicant's email address, but the phone number is optional. The address is a lookup postcode functionality. If it is that the applicant or respondent are overseas, you can click this icon to enter a UK postcode and you can manually fill in the details. You can also use that functionality if you can't find the UK postcode that you're looking for. You can choose whether you wish to keep the applicant's details private or whether it's okay for them to be shared. Next is about the other party. So you need to give the respondent's full name, again, including middle name if they have one. Is the respondent's name different to that on the marriage certificate? Again, if you say yes, you get given the options as to how they change their name. Is the respondent represented by a solicitor, yes or no? If you provide yes, you then need to provide the solicitor's details. So this is the solicitor's full name, their reference number if you have it. You do need to provide the email address. Next, you need to do the postal address. My suggestion would be that you go for search for an organisation and find the organisation you're looking for first. You need to do anything that you can to make sure you try to find this organisation, because this means there are registered solicitors and it means that they can fill in the AOS online rather than having to do a paper copy. Once you've found the solicitors and you've selected the solicitors, you can then copy and paste that address into the address box above. Alternatively, you can type it out. It does need to be in this format, suggestion of being the name of the solicitor's firm, followed by the address, and it does need to be on individual lines. Next, you can provide the respondent's email address if you've got one. And you do need to provide the respondent's postal address. Again, you've got the lookup functionality, or you can enter it manually if they're abroad or if the address doesn't pop up for you. If they aren't represented by a solicitor, you will click no. You are asked to provide the email address for the respondent. If you can get hold of the email address, it is advised, as with the new law, they will be served by both email and via post. So if you have got an email address and you can provide that, it might mean that they can respond faster than waiting for the postal. Details from the certificate. This will be the marriage certificate or civil partnership if you've chosen the dissolution. The date of marriage and how the names appear on the certificate. And did the marriage take place in the UK, yes or no? If you say yes, you won't be asked anything additional. If you say no, you need to enter the place and country of marriage or civil partnership. Next is the jurisdiction. And you can tick any that apply. Due to the new law and the fact that you can now apply online, there are specific ones for civil sex partnerships only and for joint applications only. And we've now included the both parties, so you haven't got to tick respondent and applicant. Tick all that apply and then click continue. Are there any other legal proceedings? If you say yes, you're asked to provide as much information as possible regarding the other legal proceedings. If you say no, you can just move on. Financial orders, this is whether the applicant intends to apply for a financial order. If you say no, you can continue. If you say yes, you need to choose whether it's for the applicant or the children. Next is where you'll upload your marriage certificate or civil partnership certificate and any additional documents that you may want to provide, i.e. deed poll. You no longer need to upload a D11. If you want to apply for dispensed with service or alternative service from the beginning of the case, you can now do so using the portal, but you need to wait until you've submitted the application and then follow the general application guidance that will be on the My HMCTS website. Upload the documents that you would like. The date's optional and the file type is optional. It is advised if you select it, it at least tells the court, what document it is that you've uploaded. Next, you get to check your answers. If you need to make any changes, you can click the change button at the end of any of these, and that'll take you to that part of the application for you to make any amendments. If you're happy with everything that you've put in there, you can click Save Application. This has drafted your application, and you'll note that the end state is draft, so this has not fully submitted and it is only in the draft state. In the Documents tab, you can find your drafted application. So you can click on that, it'll open in a new tab. You can download that and send that to your clients for them to have a look at before you submit it. In your next step drop down, you've got options to amend the divorce application. So should you wish to make any changes, you can go in there first. You can also update the applicant's contact information should you wish to do so. If you are happy, you can click Sign and Submit. You've got the Statement of Truth and Reconciliation. First question is this an urgent jurisdiction case or for any other matter? If you click yes, you get a supporting information box. It is optional, which is advised that you put something in there so as the CTSE and courts can see why this is an urgent application. Next, you have a choice of whether you would like to serve via solicitor service, which used to be personal service, or whether you'd like to serve by court service. If you choose solicitor service, it does pop up to say that you will need to confirm service within CCD once you have completed the service. The new clause within the law is to pay attention to the service times, which I believe is 28 days to serve. And if you need an extension on that, you need to do so on a D11. If you choose court service, the court will serve either via the email address or postal address that's been provided, or both if they've both been provided. Statement of reconciliation, the prayer. Statement of truth, that the applicant believes that the facts stated in this application are true and that you're duly authorised to sign the application on behalf of the applicant. And then your name and firm name. You can add any additional comments if you like in here, but it will not form part of the application. Next, we'll go on to the payment. If you choose help with fees, you're asked to provide the help with fees reference number that you should have applied online for the help with fees. Or you can choose PBA. Select your account number that you want the fees to be taken from and provide your payment reference number. You get an order summary page to tell you the fee. Again, you get to check your answers on the sign and submit. Again, you can go and change with the change hyperlink, take you back to that part of the application. If you're happy, you click submit application. You get a green tick at the top that says sign and submit has been updated and it is now in the submitted end state. This has now gone through to the court and the court will be able to see this application and will be able to issue it for you. And that's how to put in a sole application. Thank you. Part of the application that you wish by clicking the change, and then you will have to go back through the application again until you get to this screen. If everything's okay, you can click to save the application. Once you've saved the application, it will be a draft application here that you can send to the party for confirmation. If you are happy, I'll just click on show you the PDF that comes up. It does generate a full PDF document for you. And this shows you what the generated document is. If you're happy with everything, you can then put invite applicant to. If you need to make any amendments, you can click to amend the divorce application. That gives you the opportunity to go back and make any changes. We can invite applicant to. System's changed to say awaiting applicant two's response, and applicant two will receive an email. For the purposes of this video, I am using an inbox that's just to show you what they can receive. So they'll get this application here. that says that they need to respond and that you've put in a joint application. They'll click this link and they'll create an account. Then get an email to confirm their email address. And they'll click confirm. They then need to create a password. And then they can log into their account. They then get taken to a page where they need to enter the access details that were sent to them on the first email. So they get sent the reference number that was generated and a unique access code. This then takes them to a screen that tells them they need to review the joint application. So they'll answer their own questions. So they have to admit that the marriage has broken down irretrievably. If they say it hasn't broken down irretrievably, it does tell them it must have done. And if they click continue, it will say you cannot apply to get a divorce, and they'll click to end the joint application. You'll then receive a notification to state that the applicant 2 has not agreed to the divorce, and you will need to do a new application as a sole applicant. If, however, they confirm, they can continue. They check the details that have been populated by yourselves, and they can make any amendments. The bottom question is pre-populated from the answer that was provided by yourselves in the application. They can then answer the top question as to whether they changed their name when they got married or not. And they can change this answer as well if they wish. They then have to agree that the notifications can come to them via the email address that's been provided, and they can provide a phone number if they've got one. You can then choose whether the details that they're going to provide for address needs to be kept confidential or not. Then they'll check the address details and they can make any amendments to this that they see fit. And here they can click to enter UK postcode if they need to change that address. They then get to say if there was any other cases relating to the marriage. They say yes. They have a free text box, which tells them that all information needs to be provided. If they say no, they can just carry on. Next, it goes into some information about financial orders. How they go about applying for a financial order. If they say yes to applying, they get to choose who it's for. If they say no, they can continue. And it tells them again how they can apply. They then get to check the answers that have been provided by the solicitor firm and confirm whether everything that they're reading there is accurate or not. If they agree, they say yes and it'll go through. If they don't agree, they can explain what needs to be changed. This will then come back to you on a notification. You can make the amendments to the application and then send it back for review again. They say yes and continue. They then check their own answers. Again, they can make any changes by clicking the hyperlink at the end, and it'll take them to that point of the application. If everything's okay, they click continue, and then they confirm the joint application. They then sign the prayer and submit. It then informs them that this has gone back and that this is the date that they need to, they should expect to have a response, which is 14 days. The solicitors should then receive a notification which looks like this, that says that the other applicant has reviewed the joint application and it can now be submitted, and you can click that link. Once you've clicked the link, you'll need to log in. And then you'll be shown the case. Applicant 2 is approved, so you can now go in on your sign and submit. Or you can do your statement of truth and reconciliation. You can choose whether this is an urgent case for jurisdiction race. If you say yes, you ask to provide supporting information, which is an optional box, so you can either provide it or not. Say no. And then have you discussed the possibility of reconciliation and your prayer. And the statement of truth. And then your name and the solicitor firm name. You're then taken to the fee. If you choose to pay by Hout Fees, you are asked to provide the Hout Fees reference for both applicants. As for a joint application, both applicants need to be eligible for Hout Fees in order to put Hout Fees claim in. Or you can pay by PBA. Select the account PBAs to come out of and include your reference number. Next screen confirms that we're taking £593 from the payment method of fee account and the reference number. You then get to check your answers. You can go to the hyperlink to change any answers. If you're happy, you can submit the application. The joint application has now been submitted and you've got an event at the top that says sign and submit. When you go into the documents tab, you click the joint application at the top. This is both sets of answers that have been provided, applicant 1 and applicant 2, in the draft format. And that ends how to put in a joint application. So the reason the joint video started partway through was to save some time for questions and answers. We played the sole video first, and when you apply for a sole or a joint application as a solicitor, the fields that you need to fill in for both are the same. So you're just literally choosing divorce or dissolution on that first page and whether it's a joint or a sole application. So we started it at the end of putting through the application where we get to the crucial part about inviting the other party. So we've got time for question and answer.
So I'll start with asking some questions. We've had one come through asking if an applicant or respondent does not have a personal email address, can I presume a legal professional still proceed using the portal?
Yes, so a legal professional, so a solicitor, can still use the portal and use their email address if they haven't got one for the applicant. And if they haven't got an email address for the respondent, they just put their last known, their postal address, and then the respondent will be served via post, and they'll have an option to either respond.
We've lost you there, Rizzy.
Can you hear me now?
Yeah.
So yeah, so if an applicant hasn't got an email address, the solicitor can still lodge the application on their behalf using their email address. And if the respondent hasn't got an email address, they just enter in their postal address and the papers will be served on the respondent that way.
Thanks, Izzy. Our next question is the online service available for litigants in person or only for solicitors?
The MyHMCTS part access is for solicitors only. The citizens will go in through the Gov.uk website and create an account. As we saw in the joint video, that's what applicant 2 was doing, and that's what they were using. So there's the Gov.uk website, and there's 2 different pages. You've got apply for a divorce and then end a civil partnership, which is apply for a dissolution, and they do need to use the right link when they're applying.
Lovely, thank you. We've had a question on how long is it taking for courts to issue?
So currently, we prior to the 31st of March and leading up to the 5th of April, we were able to issue the majority of the divorce applications under old law, and at the moment we're currently within 1 week in issuing new applications.
We've had a couple of people ask, what is CCD?
The court case data system, it's the digital service, it's the digital online service, and that's what we call it because it's our case management service that supports the digital online journey.
And kind of linked to that, we've had a question around, is there going to be an API digital connection that allows our case management system to pre-populate screens?
We haven't implemented that yet, but I know it's certainly being discussed with our common component team that host MyHMCTS. So it's certainly under discussion. So not to be ruled out, hopefully sometime in the future.
Let's see, will there be a sort of, one question is, why does the draft application not make it clear that it's a draft, and why have the court seal on a draft?
So I think that might be a bug in the system, but certainly it is headed, labelled draft application, and it's not got the issue date, and it's when the case is in draft in the solicitor portal. But we'll certainly look into the seal part. So thank you for that feedback.
Okay. We've also been asked, what happens if we don't know the respondent's address and we need the court to assist with a trace?
So we've got the general application functionality where you can apply to serve by another method with your general application in your D11 or your D13B, whichever one it is that you're putting in. The system currently isn't tooled up to not have an address put in it. It does need one in there. So you could put your last known one in there, or you could put even the applicant's one in there if they live together at some point and they're not confidential. It is something we can look into, but for the most part, we know that most addresses are available. And what you would do then is you would submit the application, and then as soon as you've submitted your application, file your D11 using the general application route. The guidance to how to do that is actually going live on the MyHMCTS link today, this week. So it should be available by the end of this week to guide you through it. And it's just basically filling in your D11 application and uploading it. You pay for it whilst you're submitting it, and then it goes straight into a general application queue that's monitored by the court. And it means that your case won't be issued until that D11 or D13B is dealt with.
Thank you. We've been asked, what is the correct way to submit an application to extend time for service?
If you're as a solicitor, you should be using the general application, as Kim has just touched on. So you would make an application on the D11 and submit it using the general application received event.
Okay. We've been asked, what happens if our client has not informed us that they wish to apply for a consent order at the stage of filling the application? Can we go back and edit the form or apply for the consent order at a later stage?
I think that's around the financial order question. So if they've not indicated on there, so they've indicated no, they would have to go in and request for an amended divorce application to amend that to yes. or they could make an application to the court.
If a joint application is made, which applicant 2 then disagrees with applicant 1 having to make a sole application, does that mean they will have to pay twice?
No, because you haven't actually paid when you do the invite applicant 2, because applicant 2's got to fill their bit in. If they either say that they don't agree that the marriage is broken down irretrievably, or they ask you to make amendments that you don't agree with, you haven't paid because you haven't got to your sign and submit and your fee screen. So you would just create a new application as a sole applicant. If they have said that they want to make amendments to the divorce application or dissolution application, that is entirely up to you whether you do make the changes that they have requested, or you can just refile it to them again as an invite applicant 2. That's entirely up to you.
Okay. Can solicitors be added to the new online divorce if they're instructed after proceedings have already been issued?
Yes, we've got a new notice of change functionality that means that the staff at the CTSC can instigate notice of change for you. If you're a registered solicitor and you can be found using the organisation lookup, it will mean that the case will be a digital case and that you will then get a notification from the court to say you've been added to the file, and your CAA can look you up in the unassigned case list and assign that case to the solicitor. If you, however, cannot be found as a registered solicitor, it will mean the case will move to an offline case, so you'll have to file everything via paper to the divorce and dissolution PO box that's on the Gov website. We are going to improve this later in the year and make it so as solicitors can also do the notice of change themselves through the portal, so that's pending.
Yeah. Someone has asked, is there scope to expedite a divorce where the applicant is terminally ill?
Yes, same as how it was in old law, so you can make your application to do that, again using the general application received event if you wish to do it digitally.
Okay, let's see. Someone's asked, do you apply for a conditional order via a paper application or online?
Online. The guidance for conditional order will be uploaded onto my HMCTS soon, and also the final order part as well. We're just finishing that off and that will be uploaded soon.
Okay. We've been asked, how many applications have so far been issued under the new law?
I think we've just actually, we've received quite a lot. So I think we've received around 3,000 applications at the moment, but we can come back to you and confirm how many we've issued. But yes, we're turning them around currently within a week.
We've been asked, if a respondent states that the marriage is not broken down and the applicant has to apply as a sole applicant, do they incur a whole new fee to support the sole application, which I think is similar to the previous question, but just to double check.
Yeah, so no, because you haven't paid at that point. You only pay once the applicant 2's actually confirmed that they're happy with the application and you go into your sign and submit. You don't get any payment before that point. So if it's not agreed, then you just create a sole application and then it's just the one fee on the sole application.
We've also been asked when the online divorce service will be available in Welsh.
Will be coming shortly, so hopefully in the next couple of months.
Okay. We've been asked, if a respondent refuses to accept that a marriage is broken down, can they stop proceedings?
Only if they choose to dispute the divorce or dissolution, which obviously can only be done on the grounds of jurisdiction or validity of marriage, and they would file that with the D8B as in old law. They can file a D11 to do an answer out of time as well if they want to, but if they didn't agree to it, then it would be up to the legal advisor if they chose not to dispute.
Thank you. We've been asked, if a petition has been made before the 6th of April, will we still need to wait 20 weeks for the decree nisi?
No, because that's if it's been issued under old law, so issued prior to the 6th of April, it will follow that procedure. So you apply for your decree nisi. You don't have to wait for the 20 weeks because it's under the old law.
Okay. And what happens if parties do not agree the date of separation?
You no longer ask for a date of separation with a new law, so that would only relate to like your 2-year and 5-year. The only clause to put in a new law is that you've got to have been married for 1 year before you can apply for a divorce or dissolution. So it doesn't ask you any separation dates or anything throughout the application.
Okay. We've been asked, does the court charge for any amendments as previously?
Yes, the amendment fee will still apply. If you need to amend the application for any reason, it would be the £95 fee.
Okay. Okay, so I'm going to do my best with this question. Why are the case notes not reflected on the history page when you click on different stages and only viewable when you click into each stage and have to try and find detailed information?
So the case notes aren't viewable by the solicitor anyway. They are for the caseworker to enter. So you shouldn't be able to see the case notes anyway, either from the tab or the event history. But if you think that's not correct, then obviously please email us. We'll provide some email addresses after if we need a bit more information on that.
Okay. Another question we've been asked is, if in a jurisdiction race case where applications need to be issued immediately, is that the case? Does that happen? Will they be served on the same day?
Yes, so we have the urgent flag on the online system, so you can select that and put your reason in for the urgency, which could be a race for jurisdiction, and that will get referred to the district judge, will be picked up as an urgent and referred to the district judge.
We've been asked, what's the process for claiming the cost of a divorce?
If you want to file to claim costs now, you need to do so on a D11, and you would file that under the general application receive functionality that we mentioned earlier. Like I say, the guidance should be up this week for that, and Kim, if we let you know, you can get that publicised for us, the link, and say that it's live. But yeah, that should be available by the end of this week. But it is in the next step drop down, and you can see it from any state within the case, and you can claim costs right up until final order. Once final order's been done, costs can no longer be claimed.
We've been asked, how does one obtain help with obtain the help with fee references?
So there's a help with fees application that you would fill in, and the link to that is on the Gov website on both the divorce page and the End Civil Partnership page. If you click there, how to get help with court fees, and it'll take you through. And it's just basically an online form of the EX160. So you're just filling in an online version of the EX160, which has been streamlined. So you fill that in, it gives you a code at the end, and then you can file that onto the divorce or dissolution application.
Okay. And we've been asked if payment can be split between parties for a joint application, so each person kind of paying half to HMCTS.
The fee needs to be taken in full because the system that's used is PayBubble, and it can only take the payment in one go. So what we would suggest is if you wanted to split it, then that's organised between parties, so they could do bank transfers or things like that, and then you just call to make the payment, the one fee that's required.
And can a nullity petition be filed by the portal? And if not, where should they be sent?
No, they should be sent to Bury St Edmunds, which is the regional divorce unit. So both nullity and judicial separation, you need to complete the paper forms that are available and send them to Bury St Edmunds. We will be looking to move that area of work into the CTSC in Stoke later in the year.
Okay. We've been asked, How does the court calculate how much each party should pay when they're both applying under help with fees? Is the court fee split equally between them and then the usual help with fee calculation?
So the help with fees code's entered onto what's called a DWP checker system. That checks that we have to put in, and you do a lookup on that, fill in all the information, which is what the form is that you're applying for, so it knows what fee you're taking. It then comes out with the output of what the help with fees is, and tells you whether it's granted in full or a part payment or refused, and how it was refused, and the court will relay that back to you. On a joint application, if it's part payment required, we can do a breakdown to tell you what the part payment is for both, but we will add those two together and give you a grand total fee that is required on the account, so that how you know how much has got to be paid in full.
Brilliant. We've been asked if litigants in person are signposted to mediation before they make an application for finances, and what about the MIAMS requirement?
That is included in the financial remedy consent order service and system, and also but not in divorce, but it is available on gov.uk as well. There is guidance around mediation on gov.uk.
Brilliant. Okay, gosh, we are absolutely rattling through these questions. Let's see. There's a lot around fees and if people are required to pay twice if a respondent doesn't agree to the application. Is there anything more we need to say or any guidance we need to point people towards after the event, just so that we can kind of point people in the right direction, because this is coming up quite a lot. Might be one for the end. Next question is, if the respondent states that the marriage is not broken down and the applicant has to apply as a sole applicant, again, do they have to apply? And I'm guessing, Kimberly, that will be a no because it hasn't been issued. Please correct me if I'm wrong.
Yeah, because the reason you don't have to pay twice is because once the joint application gets put through and you do the invite the applicant and it goes to the other applicant, if they then don't agree and they say that they don't agree that the marriage is irretrievably broken down and they click to end the joint journey, that just ends the joint journey for you and you can't go any further because applicant 2 has refused to say that it's broken down, and then you would just apply again as a sole. And as I said, you don't get to a payment point until you've had that approval back from applicant 2, and then you go in and you click sign and submit. So until then you're not putting any fee information in, so you won't get charged twice. You'll only get charged when you put the sole one in.
We've been asked, how do we add a respondent's legal representative after the divorce has been issued?
So you would send in a notice of acting to say that there is a respondent solicitor with the full address details, and then the court will instigate notice of change, and they'll then do the lookup to see if they're an organisation that's registered, which will mean that the respondent solicitors will be offered the digital platform. If it is that they're an unregistered solicitors and they can't be found in the organisation lookup, they'll be offered paper outputs.
We've had a few questions on people having to sign in twice before getting into the portal and whether that's something that's going to be resolved.
That's to do with the multi-factor sign-in of the service, and it does depend what browser you're in. What we can do, we can follow that up after with the event if you like, because that's not something that our service team is in charge of, but we can certainly get more clarity around that.
We've had one question around accessing old law cases. So when the questioner searches for their old cases using the reference numbers, nothing comes up. Is this a known issue, and is there a fix that you can suggest?
If you're using the search functionality, you need to ensure that you choose the right option at the top. So in your case filters, you need to make sure you're in divorce if it's for old law, and if it's for new law, you need to be in new law, and then it should find the case for you if you're doing it via search. You just need to make sure you're in the right one, because if you're in new law and it's an old law, it won't find it, and vice versa.
Similarly, we've had a question on accessing submitted cases. How do people find them? And how does this, where does the submitted case go if it's unassigned?
So I think there is an issue with some solicitor firms. We're getting some feedback around solicitors not being able to access their case in the unassigned case list. So if you are one of those solicitors that are having problems, if you could please let us know, because we will then escalate that issue. We've only had a couple of solicitors that have told us that they're having issues, so we're not sure whether this is a system issue or whether it's user issue. So if you could just let us know, the more information that we have, the better and quicker we'll be able to deal with that issue, please.
Brilliant.
But I will add to that, if you are the solicitors that have filed the case and you want to see it in your submitted queue, in your case list, you just need to choose your filters correctly again. So it's, if you're looking for old law, you choose divorce. If you're looking for new law, you'll choose new law. And then if you choose a submitted queue in your next drop down, then it'll show you anything that you've got that's within your submitted queue. If you set it to any, it'll show you the case wherever it is and what state it's at.
We've been asked if the address confidentiality is opt-in or opt-out.
It's entirely up to you. It's whether you say yes to confidential or no. So that's a decision for you to make as the applicant as to whether you want to keep your details confidential or not.
Okay. We've been asked how people apply if their client is in receipt of, I think it's legal aid.
So it's up to the client and the solicitor whether that legal aid covers the solicitor or not. I don't know, but it's entirely up to you whether you apply in person or having a solicitor representing you.
We've been asked what happens if the respondent does not return the acknowledgement of service? Does the application stall?
Yes, in new law, you do still need to have an AOS come back. So if the AOS goes to the overdue state, which happens on the 17th day, because we allow 14 and 2 for postage, it will move on the 17th day to overdue, and you'll be notified that the case is now overdue and that you need to do something to move that case forward. So the options are still the same as what they were in old law. So you've got your likes of alternative service, deemed service, dispense with service, and you would file that application using general application received.
Well, we have been asked, what's the procedure for making a D11 application?
So the guidance will go up this week, but you basically go to your next step drop down and you choose general application received. This will then take you to a screen where you will upload your application. So you do need to download the application and manually fill it in. We haven't made the form available through the process. You have to upload it. You're then taken through the options, so choosing which fee it is, whether it's the £53 fee or the 167 fee. So it's on notice or with notice. You then need to provide information as to what you're filing for. So you've got various options, including other, to choose which radio button it is that your application relates to. You can add in additional information in any of the boxes that are on there. You then continue through and you have to either provide a help with fees reference or your PBA again and your PBA reference number, and then you'll submit and it'll come through to a general application received field in the CTSE, and they'll manage that state. So you don't need to let the court know it's there. That will be a state that will be managed by the staff.
Just in related to that, I think there's a few questions coming in around applications. So the service works the same as old divorce law, in that you make, as Kim says, you can make your application using the D11 application form or the D13B if it's dispensed application. And you can still do that. You either fill in the paper form or you can use the general application received event. Another question was around will we now be able to lodge a consent order application online where there is a foreign divorce certificate? We've always been able to lodge an application for a consent order even if there's a foreign divorce certificate. And longer term, we will be looking at digitalising that general application process.
Okay. Some other questions we've come through, quite practical. Can cases be deleted from your list when the divorce is completed?
Not currently, no. What we have got in our backlog of work to do, which is the ability to archive the cases. So a solicitor may have made an application but then started again. So we want that ability for you to be able to archive it so you can put it in a folder or in a state in CCD in the case management system.
How do you stop? How do you put a stop, sorry, on the final order being applied for if you have financial proceedings pending?
Well, you don't apply for your final order if you don't wish to apply. You have to do it. You get a notification after the 6 weeks and 1 day, like you do on old law, to say that you can now apply for your final order. So if you don't wish to make that application, you can just not make that application.
Okay, let's see. We're getting lots and lots of questions coming through now. Let's see. If the AOS is overdue, what do you need to prove for deemed service?
So it's proof of service, so proof that you've served the application yourself, or proof that you've got like a text message, WhatsApp, email or something like that that proves that the respondents actually received that document, and you can provide that to the court. And then it'll be up to the legal advisor or the judge if the evidence that's been provided is enough to prove that the service has been successful and that they can be classed as deemed served.
Okay, let's see. If an applicant does not apply for the final order, can the respondent make the application, and if so, how? And how long will they need to wait?
It's the same as old law, so it's the 3 months after the 6 weeks, and they will be able to make that application online as well.
Okay. There's a really practical one. Can you change the solicitor's address?
Yes, you can. You've got update contact information, so you've got the update applicant information, so that'll let you update the actual applicant on the case. And if you want to change your address details, you can either go into update contact details or you can let the court know and the court can do it for you.
Okay.
I think we've had a couple of questions around court service as well. I mean, the court will serve by email as default. And by post, so we'll send a notification through our GovNotify service, and we'll also send the notice of proceedings out by post. You can choose for solicitor service if you wish. That is a decision down to you, but if you don't choose solicitor service, the court will serve.
Okay, just mindful of time, we're running out now, so we'll just do 1 or 2 more questions and then wrap up. Please clarify if a respondent has received the divorce papers and then instructs us to represent them, and we notify you by post or electronically that we are now acting for the respondent. How do you get us into the portal?
So if you're a registered solicitor, when we instigate notice of change, we will look you up on the organisation lookup, and that'll tell us if you're a registered solicitor or not. If you are, then we'll put that address in, we'll go through the notice of change, you'll be added to the case, and you'll get a notification then that tells you you've been added to this case and you've been listed as acting for this party, and your CAA needs to log on and allocate that case to you with the unassigned case list.
Okay, brilliant. And then how can we ensure that all members of our family team can access applications made by other members of the team? Can admin do anything to enable sharing of all cases submitted by the firm?
So you've got share a case functionality, and on new law we have made that available in the draft state as well. So when the case is still in draft, if you go into your case list and you choose your draft list, you've got the option then to share your cases there. But you can share at any point within the application, and all you need to do is look up find the event that you want. So if you want to share all cases, you should be in any, so new law and then any, click apply. That'll show you all of the cases. You'll have a little tick box at the end of in front of the case number. Tick all of your boxes, click the share a case at the top, and then you'll be able to then put in the email address of any employees that you want to add that case to, and then it'll share the case with all of them that you've put in. And you can put multiple email addresses in and one for each one.
And this is going to be our final question today, and this has come up a few times. Do we file a divorce application in the applicant's maiden name or the surname she assumed on marriage?
You would put the married name in if they've changed the name at marriage, because once you put the name in, it does ask you, have they changed the name since they got married, yes or no? And when you click yes, you just then pick how, and you're sending off the marriage certificate, deed poll or other are your options. So you would put it in their current name, what they are now known as, and then you would tick that.
So I think that's us out of time for today. So thanks to everybody for joining the webinar. We really hope you found it informative. We will provide a recorded version of the event, and there'll be links to the slides and the videos. So please look out for that, and you will get an automatic notification when that's available anyway. Please also take the time to complete a little survey that will come out about the event, so that we can improve and take on board your feedback. But otherwise, I think that is our time up.
Thank you.